Dear students, in the previous lecture, we were talking about the categories of the crimes according to the gravity, and I illustrated that we have three types of crimes according to the gravity. The first type is called the felony, the second type is the misdemeanor, and the final one is the contravention. And we highlighted the most important differences between these kinds and what is the importance of such um, differentiation between these three kinds of uh, the, the crimes according to their gravity. In this lecture, inshallah, we'll move to another category according to which the crimes are classified. So the second criteria is the types of the crimes according to the interest which is affected by the crime. So by looking to the interest which is harmed by the criminal act, we can say that the crimes are divided into two big classes. The first one is called the normal crimes, which is here, and the political crimes. So the crime is called political, and it is prescribed as described as political when the motive, which like encouraged the person to commit his crime, is a political one. Like those crimes, for example, who are committed against the political figures or the most important people or the VIP people inside the society. So these are called political crimes, like the assassination of certain figures inside the society. This is called political crime. However, the other crimes who are committed against the normal people, they're called normal crimes. In a way, whether they are normal crimes or political crimes, the crimes they are maybe directed to the the persons. I mean, the persons as a human being, or even they are directed against the money or the public good. So we can say that there are three crimes also, three types of crimes according to the interest affected. Some of these crimes are crimes directed to persons, like the crime of murder, the crime of, um, for example, battery, جريمة الضرب, whatsoever. We have another kind, which is the crimes against money or property, like crime of theft, crime of embezzlement, crime of, let we say, crime of. By the way, the theft has two kinds according to comparative law. We have the grand theft and we have the petty theft. And we will differentiate between these two kinds, inshallah, in the second part of uh, the criminal law, which is the private criminal law. And this will be taken, inshallah, on the third level, not the second level in a way. And we have crimes, by the way, crimes against the, for example, what we say, the public order or the public health, the public good ضد النظام العام، زي الجرائم اللي احنا بنسميها for example um, bribery، جريمة الرشوة، جريمة counterfeiting of money، تزوير العملة، تزييف العملة عفوا، إلى آخره، وتزوير المحررات الرسمية التابعة للدولة. Then these are the crimes according to the interest which is affected by the criminal act. So there are crimes against persons, there are crimes against money, there's crimes against the public good. Anyway, these are the crimes according to the interest which is affected by the crime. Anyway, these are articles, these are examples for crimes against the interests, whether they are persons, normal persons, or public persons, political persons. or even against money, against public good, or even against the persons. The third criterion according to which crimes are divided is the actus reus. Well, the actus reus of the crimes, it helps us in deciding what is the type of the crime that we are talking about. And actually, the type of the crime, according to its actus reus or according to the actus reus of the crime, it is very important simply because it helps us deciding what is the temporal jurisdiction of the courts, what is um, the local jurisdiction of the courts, or what we call the jurisdiction ratione loci. And actually, it helps us regarding in deciding matters like the prescription. When does it start? When does it end? So these are very important matters uh, that are linked with and connected to the crimes according to the Actus Reus. So what are the crimes according to their Actus Reus? Well, we have many types. So according to the Actus Reus, we have positive crimes and negative crimes. We have instantaneous crimes, we have continuous crimes. Also, according to this Actus Reus, we have simple crime, we have compound crime. So we have habitual crime. So all of these and the sequential acts whatsoever, I think I highlighted them before, but in brief. However, here I'm going to talk about them in more details, inshallah. Anyway, these are very important classifications according to the criterion of the actus reus of the crime or the material element of the crime. Anyway, the first category is the positive and negative crimes. Well, the positive crime, we can name the crime as a positive one when the actus reus of this crime or the material element of this crime takes the positive tangible act. Like, for example, when I talk about the crime of murder, what is the actus reus of the crime of murder? Like, if I kill someone by shooting, then the actus reus here is the shooting act. So the shooting act is a positive act, and I don't mean with the word positive that it is a good act. I mean, the person here, he exerts efforts. He exerts efforts in committing the act, the criminal act. So it is positive one because the person, he does, sorry, something. And also it is tangible because it can be seen by the other persons. So it is a positive and tangible act. So when the act is a positive and tangible act, we can say that the crime is a positive one. So the crime of murder by shooting, the actus reus is the shooting act. The shooting act is a positive and tangible one. And also the crime of theft, What is the actus reus of the crime of theft? The actus reus is taking others' property. So the act taking, it means that the person commits positive act and a tangible act because it can be seen and the person can be stopped and whatsoever. So this is called a positive crime. So the positive crime is the crime where its actus reus is a positive and tangible act, like in cases of murder and theft. However, the negative crime is the crime where the actus reus takes the withholding form. Withholding means the refrain. Let me write it. So it is REFRAIN. So refrain doing something means withhold. Withhold means not to do something, not to do something. Like, for example, withholding giving a testimony, withholding to breastfeed the baby. I mean, not to give him the milk, leading to his death. So this is a crime of murder, but it didn't happen through a positive act. It happened through a negative act because the mother is legally obliged to give her baby the food or the milk. But when the mother here in this example withholds from breastfeeding her baby, leading to his killing or leading to his death, then the mother here is accused and is guilty of the crime of murder. However, what is the actus reus of this murder? It is not a positive act, it is a negative act. And we describe it as a negative act simply because it did not happen through a positive act. It happens through a negative act, which is the withholding. I mean, the refrain as attitude that happened by the perpetrator. Okay, so this is the example when the safeguard, because at the shores, at the seashores, sometimes, or it is usually happens that we have safeguards. So if the safeguards saw a person, and this person was sinking in the sea, and he was about to sink and to lose his life, but the safeguard withheld and he refrained from doing the obligations that he has, which is saving this person, leading to his death. Then this person, I mean the safeguard in this case, is considered a committer of a crime of murder. But he did not commit it through a positive act, he committed this crime through a negative act. Okay, so there must be an obligation anyway. Okay, so to have a negative crime, the person shall refrain from doing something which is obligatory to him, but this obligation shall be a legal one, not a moral one. Okay, so this is the positive and negative crimes. Also, we have types of the crimes according to the Actus Reus. We have the instantaneous crimes and continuous crimes. Instantaneous crime is the crime which happens and ends in a short time or in a certain period of time, like crime of murder, crime of theft. Let me illustrate this. Now, imagine that A wants to kill B. So A shot B, leading to his death. Now the question here, does the act of shooting cost that much of time? Well, actually the answer is no, because the shooting act, it happens and ends in a short moment, right? So because the actus reus happens and ends the same time, in a certain time, in a short period of time, we call the crime of murder as instantaneous crime. يعني جريمة وقتية، جريمة لحظية, simply because it happens and ends in a short period of time. Also the crime of theft, the person when he enters the house that he wants to steal, then he took everything inside the house, then he ran away. And in this example, does the act of taking the other's property cost that long time? Well, actually the answer is no, simply because I am as a thief, I will enter or break into the house, then I will take the matter that I find, then after that I will run away. So it may cost me just half an hour, 1 hour. In all ways, it will not be it will not be costing me that long time. That's why we call it also instantaneous crime or جريمة لحظية أو وقتية. So the crime of murder, the crime of theft, the crime of rape, the crime of battery, the crime of robbery, the crime, I mean, most of the crimes, I mean, 95% of the crimes are instantaneous ones. However, the continuous crime, we call it continuous because the actus reus, or the act which constitutes the material element of the crime, it constitutes for a long time. So it's the opposite of the the instantaneous crime. The instantaneous crime, it happens in a short time, or it doesn't cost me that long time. Like the bullet comes out from the pistol and kills the victim in a blink of an eye. However, The continuous crime, the actus reus of the crime, it takes a long time. And we can say that the crime is existed as long as the actus reus exists. Let me give you an example. Now the concealment of the stolen things. جريمة في عندنا قانون، في قانوننا قانون العقوبات 74 سنة 36 في حاجة اسمها حيازة الأشياء المسروقة. And you have to differentiate between the concealment of the stolen thing and the crime of theft. The crime of theft is something which is punishable, and we have penalty for the crime of theft. And we have another crime, hiding the stolen things is considered another crime. So when Baha, for example, or Ahmed Masood, for example, when he steals something, then he hides it inside his house, then Ahmed will be accused of two main crimes. The first one is the crime of theft because he stole something, and the second one is the crime of concealment of the stolen things. Hiding them, whether in his house or anywhere else. In all cases, the person here, in this example, Ahmed, will be accused of two different acts and crimes. The first crime is a crime of theft. The crime of theft is considered instantaneous crime. However, the second crime is the continuous one. The concealment of the stolen thing. Why do we consider the concealment of the stolen thing as continuous crime? Well, actually, because the continuous crime here, or the active reason of the concealment, is the concealment itself. موضوع حيازة الأشياء المسروقة، إيش هو الركن المادي في جريمة حيازة الأشياء المسروقة؟ حيازة الشيء. فبنقول طالما إنه الحيازة موجودة، إذا الجريمة موجودة، ستبقى مستمرة طالما الحيازة موجودة. So the act is real in this example, it takes a long time. That's why we call this kind of crimes a continuous crime. Also, when we say uh, having a pistol, for example, or having a gun without a license, هي سلاح بدون ترخيص. It is considered as kind of a continuous crime because this crime will continue as long as the actus reus, which is having the gun, continues. So we can say that this is another example for the continuous crimes. Also, withholding submitting the child to those who have the right to embrace him. Like when I kidnap a child, the act of the kidnap or the kidnapping is considered a crime, and it is instantaneous crime. So the crime of kidnap is instantaneous crime. However, there is another kind of crimes here in this example, which is withhold submitting this child to his father or to his parents. In this example, we can say that this crime is a continuous one. So as long as I withhold submitting this child to those who has the right to place him or to has rights on him, this crime will continue. So we can say that the continuous crime is maybe committed through a positive act, or even it may be take the negative shape, like this example, to withhold submitting the child to those who have the right to embrace him. Anyway, the continuous crime differs from the instantaneous crime that leaves a continuous result impact, like the battery that leads to sustained disability. Um, don't don't take it into consideration if you have difficulty in understanding this point. However, I will illustrate it. The continuous crimes means that the actus reus of the crime continues. However, it may that we have instantaneous crime, but it has a continuous result. Okay, so there is difference. There is continuous crime, and this continuous crime means that we have continuous actus reus, and we have instantaneous crime, but it has a continuous result. For example, I committed the crime of battery towards my wife. Okay, but through this battery, I, for example, broke the the upper jaw or the lower jaw of her mouth. So in this example, we can say that the battery is instantaneous crime, but it leads to sustained disability regarding her lower jaw. So in this case, we can say that this is not a continuous crime. We can say that it is not. We cannot say that it is a continuous crime because what is continuous in this example is not the actus reus. It is the result only. Okay, the effects, the side effects of the crime. Okay, so there is difference between the continuous crime and the instantaneous crime which has continuous result. Okay, this example, I don't need it actually. I didn't need this point if you have difficulty with dealing with it. Anyway, what are the results of this subdivision? It well, actually, differentiation between the instantaneous crime and the continuous crime is important regarding the temporal jurisdiction. I mean, this classification has its effect on the temporal jurisdiction, and it has difference regarding the geographical jurisdiction, and it has important um, results regarding the prescription of the criminal action. Let me give you an example here, and I would like to use the whiteboard. Let me consider that this is a crime of theft, and this is concealment of the stolen thing. Let we consider that the act is raised of the crime of theft. It happened in Gaza, but the person, he hides the stolen things in Gaza. Then he moved them to Rafah. Then he moved them to Khan Yunis. The question here regarding the court, the competent court. Regarding the crime of theft, the competent court is the Conciliation Court of Gaza. Why? Because the Actus Reus, it happened in Gaza only. We cannot say that the Actus Reus or the crime of theft happened in two places. It must happen in one place, the place where the taking of the other's property as Actus Reus happened. However, regarding the concealment, which is the competent court in this example? Is it the Conciliation Court of Gaza, or the Conciliation Court of Rafah, or the Conciliation Court of Khan Yunis? Well, actually, all of them are competent to hear the case. But if it is heard by one of them, the others must withhold from hearing the case, because we cannot prosecute the same person for the same act many times. So all of them can practice their jurisdiction over the case. Okay, so this is why the differentiation is important, because regarding the geographical jurisdiction in the continuous crime there will be one court. However, regarding the continuous crime there will be more than one competent court. Okay, so this is regarding uh, the the geographical jurisdiction, the temporal jurisdiction. Let me consider that there was a law, خلينا نسميه the law of 2019. The person committed the crime of theft in 2019. The crime was penalized by 3 years of imprisonment. Then in 2020, there was a new law which says that this crime is committed. خلينا نقول في المثال الأول كانت 2 years. However, in the second example, it became 3 years. الشخص اللي ارتكب الكرايم of theft أي قانون حينطبق عليه؟ طبعا هذا. أما هذا القانون لن يسري بأثر رجعي، لأنه قانون أشد من ناحية، وأصلا القانون لا يسري بأثر رجعي إلا إذا كان أصلح. المهم في كل الأحوال إنه طالما إنه بحكي عن instantaneous crime اللي هي crime of theft، بطلع الأكتوس ريوس واكتشف كيف إذا ارتكب في ظل القانون القديم إذا يسري عليها القانون القديم. القانون الجديد اللي بيشدد بيسريش عليها ما لم يكن أصلح، فعندئذ يسري. أما إذا كان بيشدد فزي هذا المثال فلن يسري بأثر رجعي. هذا بالنسبة للكرايم اللي احنا بنعتبرها instantaneous crime. طب وإذا كان المثال عندي continuous crime، crime of concealment of the stolen things، جريمة مستمرة. الجريمة كانت قد ارتكبت في ظل هذا القانون، بعدين ظلت مستمرة لحد ما إجى القانون هذا. بعض الأفعال وقعت في ظل القانون القديم اللي بيعطيها 2 سنين، وبعض الأفعال الأخرى وقعت في ظل القانون الجديد اللي بيجعل العقوبة 3 سنين. السؤال من فيهم الذي ينطبق؟ بكل بساطة ينطبق الجديد، لأنه العبرة أنه الجديد وقعت في ظل بعض أعمال الجريمة المستمرة، إذا ينطبق هذا القانون بأثر فوري، ما فيش أي مشاكل. حتى ولو كان بعض أعمال الإخفاء كجزء من الكونسيلمنت أو جزء من الكونتينيوس كرايمز were committed as part of the temporal jurisdiction of the old law. Simply, if there are parts of the continuous crimes that extended to the temporal jurisdiction of the new law, even if it is most severe in comparison with the old law, the new law, which is most severe, shall be applied in this case. So that's why the differentiation between the continuous crime and the instantaneous crime is important regarding the temporal jurisdiction. So this is regarding the temporal jurisdiction. The first example was about the geographical jurisdiction and what is the court that is competent. The last point is about the prescription of the criminal action. احنا حكينا انه بكون في تقادم. شو هو تقادم الدعوة الجزائية؟ انه عندي جريمة ارتكبت، المفترض النيابة تحرك الدعوة بخصوصها. إذا حركتها بخصوصها كان بها، ما حركتهاش ومضت مدة من الزمن يسقط حقها في تحريك الدعوة. قلنا إذا كانت الجريمة من نوع جنحة فيجب على النيابة أن تحرك الدعوة خلال 3 سنوات من أي تاريخ؟ من تاريخ وقوع الجريمة، من تاريخ وقوع الجريمة. فأنا عندي crime of theft. The crime of theft was committed to خلينا نقول the 2nd of February 2020. Okay, so حنبدأ نعد. We'll start counting 3 years from this date. If the 3 years are fulfilled, the right of the general attorney to provoke the criminal action against the accused will fall. ليش حتسقط؟ لأنه حيكون في عندي prescription تحقق، في تقادم. طب لو كنا بنحكي عن الكونسيلمنت حيكون 3 سنوات، بدوش يعد من وقت ارتكاب الجريمة، من وقت انقطاع حالة الاستمرار. يعني احنا عندنا كونسيلمنت، يعني السرقة صارت ب 2/2/2020 وبدأ الشخص يحوز الأشياء المسروقة من 2/2/2020، وبعد هيك نعرف موضوع، النيابة عرفت في موضوع الاستمرار في 2/4/2020. ببدأ أعد 3 سنوات من هذا التاريخ، التاريخ الذي تم العلم فيه بانتهاء حالة الاستمرار. هذا في وين؟ في الكونتينيوس كرايم. عشان هيك مهم جدا إنه أعرف إنه الكونتينيوس كرايم والinstantaneous crime they affect not only in the temporal jurisdiction but also in geographical jurisdiction regarding the competent courts and also regarding the prescription of the criminal action. That's why the differences between the instantaneous crimes and the continuous crime is very important. Simple and compound crime. Simple crime, it means briefly that the Actus Reus of this crime is a simple one. It consists of one act. Crime of murder. What is the criminal action that the person commits in this case. What is the actus reus of the criminal of the crime of murder? Like let we say that the crime happened through shooting. What is the actus reus? Is the shooting itself. So it is one act, the shooting. That's why we can say that the crime of murder is a simple crime. However, the compound crime, it means that the actus reus consist of many things, like the crime of fraud, جريمة النصب. جريمة النصب هي عبارة عن number one, there must be um, false false like claims, false claims, or even let we say lyings or lies, مجموعة كذب, and it is supported with fraudulent acts, which makes the person, I mean the victim, believes that the person who is committing the crime of fraud is honest. Let me tell you something. Now, the crime of fraud is defined in Arabic as كذب مدعم بمظاهر خارجية. Like the lie or telling the lies per se, it is not sufficient to say that the person commits the crime of fraud. The person who's telling the lies shall support these lies with fraudulent acts which show him as an honest person. Let me give you an example. Now, I'm dealing with a person as I am the person who is in charge of collecting the taxes. And I'm working in the company of the electricity. So I knocked at the door and I told him that I am the person or the officer in charge who is in charge of collecting the taxes from you as citizen. And this is my ID, and I gave him the ID which I made it. أنا عمليا اللي عملت هذه الاي دي. And I told him also that this is my badge and I'm working in the Gaza company of electricity. So the lies that I told him, it was supported with the fraudulent acts, which is wearing the clothes regarding the work and wearing that badge and giving him that false ID. All of these matters which make that person or which made that person believe in my words and my lies. These fraudulent acts are important to say that there is a crime of fraud. That's why the actus reus here consist of lies, consist of fraudulent acts. That's why it is called compound crime. Compound a crime. Anyway, this differentiation between the simple crime and the compound crime, it helps me in deciding what is the geographical jurisdiction. Simply the courts that have competence to hear the case in the simple crime is where the actus reus has been committed. However, in the compound crime, every court in which scope any of the compound acts was committed, this will make this court competent to hear the case. Regarding the prescription and regarding the competent court, all of these matters will actually the same as the idea that we or the ideas that we illustrated here. Okay, so it's simple actually. I don't think that you will have difficulty in understanding this point. The habitual crime and the sequential acts of crime, I will inshallah illustrate them in the coming lecture. I leave you in the well actually let me tell you something before I leave. Well, okay, look, I need every student of you to read the habitual crime and the sequential acts, and inshallah I will talk about them in the coming lecture. But before I end, I would like to highlight this uh, final categories of the crimes. These categories: number one, the crimes of harm, crime of danger. The crimes according to the Actus Reus are two types also. The crimes of harm جرائم بنسميها جرائم ضرر، يعني it leaves harm on the persons affected by the crime. And crimes of danger. Crimes of danger, it means it represents danger, but it doesn't leave any kind of harm. There is no real harm that affect on any kind of persons or money or property inside the society. We can say that this, look, this is the example. If we consider that this whiteboard is crimes, this dot will constitute crimes of danger, or we name them hazard crime or crimes of hazard, جرائم خطر. However, the all types of crimes here and the all other crimes are crimes of harm. So the crimes, 99.9% of the crimes inside the society are crimes of harm, like a crime of murder, crime of theft, crime of rape, crime of adultery, and whatsoever. However, the crimes of danger or the crimes of hazard, they represent only 1 point or 0.1%. Like, for example, the Article 89 of the Palestinian Penal Code 1936 applied in the Gaza Strip. Read this article and you will find it a crime of danger, not a crime of harm. Simply زي جريمة حيازة سلاح بدون ترخيص، هي لا تعتبر crime of harm، هي تعتبر crime of danger because it doesn't leave any harm towards any person inside the society. The final criteria according to which the crimes are classified, the crimes according to the mens rea or the mental element. It means the the mental state or the mental status of the person when he committed his crime. Did he intend to commit the crime? I mean, was it an intended crime؟ هل هي جريمة ارتكبت بطريق القصد or was it a wrongdoing؟ يعني لما شخص بيرتكب جريمة crime, the act of killing، فعل القتل. جريمة القتل ممكن تكون بطريق العمد، وإذا كانت بطريق العمد بنطلق عليها اسم crime of murder. However, if the act was committed not premeditatedly but in a wrongdoing act, we can call it manslaughter. جريمة القتل بطريق الخطأ. إذا في هذه بتقع wrongdoing act اللي هو زي ما هو مكتوب هنا wrongdoing act اللي هي بنسميها manslaughter, or intended crime اللي احنا بنسميها premeditatedly ارتكبت عن سبق الإصرار والترصد اللي احنا بنسميها crime of murder. هذا كان كل شيء بدي أحكيه بالنسبة لمحاضرة اليوم. أشكركم على حسن استماعكم والسلام عليكم ورحمة الله وبركاته.